notice to the defendant of their right to expungement. So it provides, and this is it's after 10105.2, and it provides that after disposition of all charges in a case involving a criminal offense or a civil offense under 5601C2, 2 of the criminal law article, so that's cannabis, including a must-appear violation of the transportation article, the court shall notify the defendant of the defendant's right to expungement. Under the subtitle, or under 10105 of the subtitle, if no charge in the case resulted in a disposition other than acquittal, dismissal, not guilty, or null pros, except for a null pros requiring drug and alcohol treatment. If the defendant is not present in court for the disposition, the court shall notify the defendant by mail. That notice would also need to include a written form for general waiver and release of all tort claims relating to the charge or charges eligible for expungement. So basically how this would work is at the time of disposition that notice is given, under current law for expungements, in those cases, somebody is able to expunge them before that 3-year window that's currently in statute, but it's subject to that waiver being completed. So the 3 years is set, it corresponds to the statute of limitations for tort claims. So if they opted to fill out that waiver, they could expunge it sooner.
So just to be clear, the amendments in front of you don't change current law regarding who is eligible for expungement or when they are eligible for expungement. It simply makes clear what the process is by which those records are expunged and make sure that everyone going forward has notice of their right to expunge, including the waiver sheet to expunge earlier than the 3-year statute of limitations. So no change in expungement, just essentially a notice provision and a mechanism by which the court can automate that expungement. This language was approved by Judge Morrissey. I shouldn't say approved, he doesn't like that. Was worked out with Judge Morrissey, who didn't have any objections to the language that's in front of you.
Thank you, Mr. Chair. So I want to be clear. So under current law, when these dispositions occur in court, the court is already obligated under current law to notify the defendant of the right to expungement. Does this now say that that would have to be mailed to the defendant as well? Is that what this is?
Judge Morrissey indicated that under current practice, most judges in his court notify the defendant of the right to expungement, but that it is not a law under current law. This bill makes clear that the right to expungement has to be provided to the defendant in court.
I think it's a current law because of the fact that in the House we passed it as a law, but that's just what I recall. We didn't do anything with waiver and release. That's still a thing, but the obligation of the court to notify the defendant of the right to expungement is law. So if it's not written, then somebody screwed up.
Okay, so to the extent that it's not happening in every courtroom, this just codifies it. The mail piece is because not every disposition is done in court. In other words, if I have a minor crime and the prosecutor decides not to prosecute, they send a letter indicating the null pros. This requires that as part of that letter, the right to expungement is indicated in that letter, and the waiver form is also provided in that letter. So I get a letter, it says, hey, we've decided not to move forward with your case, it's null prost, you're good to go. Then that's how it works under kind of current practice. Under this bill, it would also say, hey, and also, because you got a null pros, you can expunge this. You can do it after 3 years, or if you want to sign this waiver, here's the sheet inside the same mailer, sign the waiver, you'll get everything expunged.
So this does not change the waiver time.
Correct.
This really doesn't do anything except send a mailing to somebody saying these are your rights.
Exactly.
That's all that it does.
That's correct.
So,
You don't have to file notice.
Right, and yes, and makes it statewide policy.
huh?
And makes it statewide policy. To the extent different courts are doing it slightly differently, this makes it statewide policy.
And it's not supposed to be. I mean, I don't know. I'll look at it, but we really did pass a notification obligation. And in addition to the fact that I remember passing that the court had to notify the defendant, you're right. If they're, I mean, mostly everybody I know receives a notice of the disposition if they're not in court. And anyway, but there's also the brochure thing that was passed as well that they had to pass out to the people. Anyway, my point is, I'm not trying to argue because there's no problem with the bill. I'm surprised the courts agreed to do it, but I think they do agree because they already do it, except they don't mail a waiver and release. But I know they notify the disposition notification and the right to expungement.
Right. Jamie, I think we're good.
But here's what I wanted to get to. I agree with the bill. I don't think it does much more than what's already under current law. But I've been recently informed that we are the only state, or among the only states, that require the waiver and release before we allow the person to get the expungement within the 3 years. And I just wanted to suggest to us, laying the foundation for the future, that we might take a look at that in the future, because I actually think it's not good that we make people sign a waiver of a right to sue before we allow them to expunge in all circumstances.
Can we adopt this amendment? Everyone good with? All right, seconded. Everyone's good? All right. Further discussion on the bill? All right, we've got a motion. It's been seconded, so we'll do a roll call.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Hedelman.
Yes.
Sorry.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
Bill passes with amendment.
All right. Senator West, did we come back to your Senate Bill 820? Do you need a second, or do you want to?
And perhaps council could explain the amendment?
Yeah, so just to quickly recap, this bill changes a method by which wills, powers of attorneys, and advance directives may be executed by allowing them to be executed electronically and witnessed remotely. So the amendment in your packet is number 368276/1. So this amendment is mostly identical to the amendment that was discussed at previous voting sessions, but it additionally includes a requirement that a will, which is witnessed remotely, include a particular certification from the attorney that attests to the sound mind and non-coercion of the testator. So that can be found on page 6 of the reprint after line 17. The bill would now prescribe the form for that particular certification.
So the amendment's been moved. Is everyone okay adopting the amendment? All right, everyone's thumbs up on that. Great. All right, further discussion. Senator West, anything else?
I think the amendment responded to the only concern the committee had, which is the possibility of undue influence from someone who's signing a will remotely. I think we've gone as far as we can in the amendment to satisfying those concerns, and I've had some conversations. I think the concerns have been satisfied, so I move the bill.
So the motion's been made. It's been seconded. We'll just do a roll call.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
You don't have to be present.
Senator Carter.
Pass.
Senator Huff.
Yes.
Senator Carter.
Not because I don't appreciate all the work that went into it, but because I have some unreadiness about the lack of obligation to be present as a witness, and I'm not sure. I'm just going to vote no. No offense.
Chairman Smith.
Yes.
Bill passes with amendment.
Bill passes with amendments. Okay, bells are ringing, so we'll come back after.
Can we do, just real quick, because I'm good with his glass bill. I talked to my glass.
Let's do Senate Bill, the glass bill. 445, I got your amendment here. Do you have an amendment for that, or no?
Yes, there was an amendment on
I
I'm
thought I
sorry,
had an
yes.
amendment.
I move the amendment to Bill 445.
All right, so can council explain the amendment really quickly then?
Yeah, so just real quick, the bill requires the MBA to adopt regulations establishing standards and requirements for aftermarket safety glass replacement. So the amendment would mirror what was passed in the House cross-file, and it simply clarifies the specific requirements of the regulations, and I believe it was worked out between various stakeholders.
Okay, so Senator Huff, does that assuage your concerns from your guy? All right, so can we adopt the amendment? Everyone okay with that? All right, it's been adopted. The motion is for favorable, it's been seconded. Everyone's okay with that? Favorable with amendments. Everyone's okay? Great. All right. See you all after floor.